Welcome to the judge presentation. This is one of the judges for the legal challenge. If you're watching this ahead of the semifinals and finals, they'll give you an idea of what to expect, or maybe not, depending on the judge, or whether or not Karin is wearing a different hat today than she's going to wear in the semifinals. And if you missed last year's summit, then this is your chance to catch up with what's happening with MSK and Karin in particular. So, Karin, over to you. Could you introduce yourself? Where do you work? Where you're based in? And just introduce yourself as you would introduce to a new person you've met at the summit.
Sure. My name is Karin Pagnanelli. So I work at Mitchell Silverberg and Nutt, MSK. We are a U.S.-based law firm. We have offices in L.A., Washington, D.C., and New York, and I'm in the L.A. office. We're a full service law firm. My partner and I, Mark Mayer, who is also going to be at the summit, run the video game practice, and I also am head of the litigation department at the firm.
And would you say that you're a big firm, you're a small firm? I mean, of course, everything is relative. So you talk to Germans and they got hundreds of lawyers under the roof. So would you say, like, internationally, is MSK big or huge or small?
Well, we used to be a really big firm, and we started on the Paramount lot in Hollywood about 120 years ago, and we grew up and we were the largest LA firm. And to be the largest LA firm in the 20s and the 30s meant we were about 125 lawyers. We're now about 135 lawyers. And I think now we are considered either a mid-size or a boutique. But our size hasn't really changed. The other law firms all changed. We still basically handle the same types of work. And right there in Hollywood, basically, we work for the studios, we work for the record companies, the video game industry. And so I would not say we're truly a boutique. I would say we are a national full service law firm, but we do not have 5,000 lawyers.
I was thinking about MSK and your story for 120 years when I was recently diving into the archives and looking at the some of the recordings in the archives for 1901, 1902, and reading some of the papers when, like, church books. And then I would think, just at that time, there were already lawyers engaged in totally different matters in another part of the world. So, you think 120 years is,
right?
Close by or too far away, depending on how you look. And if you look at our industry, then this is, another universe. And if you look at someone who was a peasant or,
At that.
So litigation
at the time, someone had to protect those black and white movies, though.
Well, you had movies. That's good. I mean, the papers I was looking through, I don't think people had movies in that. I think they were like, trading horses or building churches or stuff.
That's true.
So how big litigation is a part of your focus, a part of your firm's focus, a part of, I don't know, American law in general, like in the video games industry? Like in the American video games industry, would you say litigation plays a role or not much? On some countries, let's say Poland, right? There's very little litigation in Poland, even though the business is booming and there's 10,000 people employed. Is America different?
Yes, very different. A lot of the laws are evolved out of litigation. So there will be some kind of litigation, and from that, somebody decides something was wrong, and they want to change a law. Or certainly people learn from, maybe a contract that wasn't enforced as intended. So everyone goes back and changes their contracts and the transactions. So in a lot of ways, litigation sort of leads the way in the way the law evolves, because litigation is a huge part of the American legal system. And at MSK, we do both transactional and litigation in the video game space. But it's amazing how much you learn out of a litigation that then counsels you on how you want your contracts to read.
And you've been with the law firm the whole career, right? Not in-house before. So
I know I did work for the federal courts. What's called in the United States, it's called a law clerk. Right out of law school, you go work for a judge, and it's kind of a typical. If you can get them, they're very difficult to get, but if you can get a clerkship out of law school, it's a really good way to train. So I was able to do that. And then, yes, I have been in private practice my entire career.
And why would you say, from your perspective, being in a law firm is more fun than being in-house? Because we have this, most of the people I know, they transferred from law firms to in-house. I know a few who went the other way around, but I would say, I don't know, 90% of the cases I know is this way. Like, in your position, why would you think law firm is more fun?
Well, I think law firms are way more fun. We get to change our client every day. So if you don't like your client or you think their work is not all that exciting, I mean, tomorrow will be another client and we'll have a different issue and a different problem to solve. So being outside you get so much variety. And so many new challenges all the time. Now there's downsides because you don't get that sense of true team. Being on an integrated team where everyone's working together for the same goal, you get it in a short spurt, but you don't get it over time as often. And I think that's where law firm life lacks, is that true feeling of working for a singular client over years to help that client succeed. But because we have the same clients usually for decades, we get it. We just don't get it in the same way.
And then when you say litigation, for example, for how long would you work along the in-house counsel? Let's say there is a litigation matter on your table and you're looking to spend with this in-house counsel, what, 6 months or a year, or is it measured longer?
Well, it just would totally depend. If it's a case that's going to settle, it could settle in weeks. It could settle in years. If you're going to litigate, it just really depends on the judge that you've had assigned and the issues. You can win in 3 to 6 months, and again, it could take years. I've had a case, Napster and Grokster took 12 years. So you can have really long cases, and you live with them, and you live with the people practically, and the issues, or you can have a case that you're able to handle and take care of and get rid of in a month.
Would you agree that the games industry, despite the growth in revenues, is still, from the legal perspective, pretty small community? That, for example, over the years, I don't know, spend 10 years in this industry and you get to know most of the in-house counsels, or there is this ongoing sort of revolving factor where there's a new games company and a new lawyer and a new counsel and a new counsel. And I remember at some point, these changes were happening, at least in Europe. You would see, okay, they got this guy from this industry and this guy from this industry, and after a couple of years he left and she left and then another, and you were looking at this and like, who are all these people? So is it more like a small club in the US, or it's still going like that?
No, it's I would say more of a small club in the US. It seems like the in-house counsel move around, but they just keep replacing each other at different roles. So you send a lot of, baskets of fruit because they got a new job, but it's still the same person and the, same issues. We're just kind of a different IP. But I think it's still pretty much a smaller group, and certainly for outside counsel. There's a smaller group in the US that knows the industry, cares about the industry, and is very focused on the industry, not just our cases, but other people's cases and other people in the companies, and follow generally, when is this game going to come out, because we're excited about it, because we know the people who've worked on it. We may or may not want to play that particular game, but we're excited about the people and the product and what they work so hard on, and that part is still relatively small.
And in your sense, is there some kind of fragmentation within the games industry, in the sense that, let's say you work with this company and they're friends with this company and then this company, but you would not work with this company and this company because they're, I don't know, they have a different ethics, or they are on the dark side or something? Like, does it exist? I know that in the techno industry, it does exist. And if you're with this crowd, you're not with that crowd, and you're like, people tend to gravitate to different sources. Is it in the games industry or not really?
It's not really in the US. The games industry is sort of following the same track as the other entertainment industry companies, the studios, the record companies, and they typically, because they have associations, work as a group, and they rarely get involved adversarially with each other, because a lot of the important issues that they have are common. So because of that, a lot of times, they may be competitors on the stage or competitors on the screen, but the issues that are important to them as a company are common. So typically they know each other, they're friendly, they may be friends, and there isn't much of a, the dark side that nobody wants to represent.
Because that's something that I didn't really understand, is that in the games industry, we're used to a games company calling another games company. And in most cases, it will end up with some helpful advice. So let's say that you don't know another games publisher, but you'll message them on LinkedIn or send them an email. Someone will connect you. And generally, people are like, yeah, sure, let's talk. And they feel like they belong to, I don't know, the same camp. Whether or not it's a loot box issue, a privacy issue, whatever, you feel like if the other guys win, you also kind of win. Is it typical for film industry and music industry as well, or is it just the games thing? Or because I know that in the tech industry, a lot of cases, I was a part of the conversations where people said, I'm not going to take his call, and they can go and lose in court, and I don't care.
I think it's that particular circumstances, I think, is more common in the game industry, just because it's a smaller group of people, and I think people tend to know each other better. But a lot of times what will happen, for instance, in some of the other industries, is they'll just call us and say, do you know what this competitor does? Do they clear motor vehicles? Do they how do they do it? And a lot of times is we say, well, do you want us to call them? Do you want us to introduce you to them? And so we just become kind of a matchmaker, and because we'll know people at both the companies, and we'll say, why don't we just introduce you over email, and you guys can talk about your issues. And a lot of times that's how they end up, if they don't know each other, because it is a much bigger industry. And if they don't know each other, they figure that we probably do, and we can just help them out. And then they all become good friends. We do events at MSK where we do, for instance, a studio night, we'll call it, at Dodger Stadium, and we invite all the lawyers from all the studios so they can just get to know each other. So when they have those kinds of issues and questions and problems, they know each other, so they know who to call.
Well, it sounds like I always thought that if you share lawyer with another game studio, you're almost like relatives, because it means that the other studio made a similar choice. And I think that it's highly personal in the sense of different lawyers. Like, there are many good lawyers, but you choose to work with this law firm and this specific lawyer in particular because of, I don't know, personality, communication, like no bullshit or more formal approach or whatever. So it means you already made this choice out of 100 lawyers. You guys are like decided. So you're like, hey, we have things in common. So probably we have the similar business or something. So I would look at the law firm or the lawyer specifically as a kind of, I don't know, not the matchmaker, but the validation that, hey, I'm not alone in thinking that these guys are the best for this matter, so I can go and do it. Great. Okay. What would you give as an advice to the competing teams who will be in front of you in the legal challenge? What they shouldn't do, and what do you think is the strongest recipe for success, like for winning? We profiled 3 teams. I'm profiling another team tomorrow. All of them are great. All of them are strong, and like I really love all of them. So we tried when we talked to them, and you will see the videos. I think I don't know if you have the time for that, but you will see that we'll try to figure what not to do. Like, if you lose, why? What would be this thing that you shouldn't have done so that we can, prevent it from happening? So in your experience, what would be the riskiest thing for the teams to do? Like, why could they fail?
Don't answer the question. If you don't answer the judge's question, that's a pretty bad response. I think, especially as young lawyers, you tend to practice an answer, and it's a way to answer that isn't answering. And the judges, they know exactly what you're doing. And what they want is an answer, your best answer. It may not be a perfect answer, but don't ignore them and then just slide to another subject, hoping that we don't notice, because we do.
Any specific advice based on the digital hearing? I mean, normally it's real life, but over the last year, I think everyone got a bunch of experience in doing this over Zoom and, being told not to go anywhere and talk to anyone and so on. We discussed with one of the teams that sometimes you're in the Zoom hearing and you hear someone's phone going beep, 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 and then they switch off, and then it's like boom, boom, boom. And you know that it's a witness who has a lawyer messaging some stuff. I mean, you cannot look into their phone, but you feel, don't do it, but they still do it, and So is there any specifics that you would like to highlight for the teams as they engage into this digital hearing?
Put your phone in the other room. Yeah, all electronics have to go in the other room. I think more importantly and harder is, what do you do with the dog? Because all of a sudden someone's coming to the door and the dog's going to bark. Recently, I was giving a presentation over the top copyright cases out of the United States for the year 2020. And I got to a case about a squeaky dog toy. And it just so happened, this is true, Sergey. I'm talking about this dog toy and my dog starts barking. I mean, it was like Hollywood made for film. So I literally had to get up, go get her, and hold her through the rest of the presentation, because otherwise we wouldn't have gone through it. So I think dogs are harder than phones, because you can put your phone in the other room. I don't know what you do with the dog.
But you would be okay as a judge if someone is distracted. I mean, I think this is kind of normalized that before the pandemics, we would be all, oh my God, there's a kid, there's a dog, and here, I had my dog here, and then she decided to go for a walk. I don't care, because I know that this happens to all the people. So, would you expect the teams to dress formally? And how formally, considering that this is a digital hearing? Like, you call Rafael at CDP, and he's got his baseball hat upside down and, totally informal guy. So as a competitor, you think, well, I want to work in the games industry. This is the guy from the games industry. He's an in-house counsel at the billion-plus valued game studio, and he's dressed like this. So why don't I skip all the formal things and dress like this for my hearing? So as a judge, would you expect people to, dress for the formality, for the occasion, or not really?
I would. I have video court regularly, and I dress appropriately. I make sure I put on a jacket, and I do all the things that one would do. At least I don't wear the shoes, but and then there's something about dressing formally that makes you sit up a little bit straighter and pay a little bit of attention and make sure that you're very on task. And I think it's all part of it, because even though we're at home right now, we're not going to be at home. Our courts are going to open up, and I'm going to be back in court, and I'm going to be back in those really uncomfortable shoes and that very restricting jacket. And it's going to remind me of, this is what being a litigator is. That's how you do it. You don't get to get up in front of the judge and in your joggers and your trainers and a t-shirt. So I think it's good practice. The other thing that I have found and I don't like is that when I do these Zoom hearings, I sit down. I never sit down in court, ever. In the United States, you don't sit down. You speak standing at a podium. And I find it hard to think and argue sitting down, because my whole experience is standing. And I have noticed that there are now lawyers who are doing their hearings from stand-up desks.
That's a very interesting topic, because I remember that we were discussing, I think with Tobias and one of the teams, what do you do if you want to stand up? As a competitor, you're like, okay, now I'm going to talk. But normally you would get up, but you cannot get up. So you're like trying to get up, but not really. Or I don't know if you remember one of the legal challenges, there was a gentleman who was very, all over the room,
yes.
and he ended up winning. So I don't know whether or not, okay, so stand-up desk is a good idea, that you actually stand, but you still have this picture that is close-up of you. Yeah, that was one of the questions. And I think that everyone is in agreement that they expect the students, the challengers, to dress up for the occasion. So that's on the same point. Yeah, sure. Good. All right. So I will not ask you which team will win. We don't know. All of them go to Vilnius. So all of them have the invitation for the September event. It depends on how fast the vaccination goes. I think by now most of Americans are, have gotten their shots, and the Russians have gotten their shots. And we are expecting to get it in July or so. So I think the Germany is now in the back of the queue, and Canada. For the rest, I don't know.
Yeah,
so we'll see. But that'll be their personal experience, and then they're all very excited about the games industry and the fact that it's like challenging and changing and so on. And I think they'll be just trying to figure you out and see what kind of judge you will be, and how they can.
I'm a very nice judge.
Very soft, I would say. Very positive, spirited, accommodating. Just nodding. Sure.
I never speak. I don't ask any questions.
And no questions at all. Then you can just, finish your presentation and then look at Karin, and she will just say, yeah, and then, do this.
Very nice job. And then I sit down. That's exactly who I am.
I think that's why they call you the feel-good judge, because everyone wants to be in this judge panel where you are. Sure.
Yeah. I don't spend, 70 hours trying to come up with the hardest hypotheticals that anyone could come up with. I don't do that.
Does it make a difference to you if everyone on the team speaks up? Let's say there is a team of 2 people or 3 people. Does it affect your decision of whether or not it was 50-50, 60-40, or it was like 80-20, and you wonder, what is this guy doing?
That's a good question, because I think it depends on the issues, because there might be an issue that's actually just harder and there's more questions. So I think it depends. And in litigation generally, how many questions you get asked and how judges react to you really isn't any indication of whether they think you've got a good argument, a bad argument, you've done a good job, you've done a bad job. It depends on the judge, him or herself, how well the judge is prepared. And sometimes the judge will ask a lot of questions because they like challenging the particular lawyer. because the lawyer's responding, and that's interesting and fun, and it's fun to discuss the issue and ask those hard questions. And sometimes you know, there might be a judge who asks a question and the answer is not so good, and they feel like, okay, well, I don't want to like make this person feel really awful about themselves. I don't know that they can handle these really hard questions. So it's interesting that everyone's different, and how judges react to someone's argument is different. And I don't think it's really telling of how a judge might feel about how well someone's doing or their argument.
I think that's a super good advice, because in my very limited court experience, that's been driving me crazy, trying to figure out if the judge asking more questions, or the kind of questions the judge is asking, projecting it into the decision and thinking, oh, she's asking this because she thinks that, so this means like, oh yeah, happy times, or, you know, oh, sad times. And then very rarely it has any connection or relation to the outcome, to the decision. So for the teams, I think it's important to distance themselves and just, you know, take questions at face value and not try to project or read the underlying thinking of the judge that's asking these questions, and why is she asking this, and how should I just, you know, do the best you can and answer it. Well, very interesting. So we got a team out of Poland with 2 participants. We've got a team out of Serbia, Belgrade, with 2 participants. And we have an international team where people are coming from Barcelona, London, and Paris. And we have a British team where both of the participants are UK-based. And I don't know, it's the strongest set of competitors that we've ever had. So, you know, good luck to all of you guys on the judge panel. I don't want to be in that room where people say, you know, this, unless someone, I don't know, fails completely and breaks down. I don't know. But
no, the judging conferences are hard.
You make such an impact on saying, yes, they go into the finals, or, you know, they win. I'm not ready to take that responsibility. I'm pretty happy that you guys are all, you know, tons of experience. So this is not a random decision. This is based on your real life experience. So it's not like you woke up and you had, you know, a nice breakfast and you were all very happy and saying, yeah, you know, because, you know, you win, or, you know. Yeah. Okay, well, and we have 1 American judge in every panel. So no one can say that a particular hearing was too American. There's 1 American in every panel. So it's a mix. We'll see how it goes. Let the strongest team. Thank you very much for joining us. I hope that by now the teams are all trembling. Or maybe... I don't know, maybe smiling and drinking some tea and saying, whew, I thought that would be harder. Okay. Yeah.
You know what? I'm almost out of that tea you gave me last February, the last time I saw you. I have like this much left. It's fantastic. I love it.
It's time to send some more. Yes. Let's see what happens in less than a month. And let the strongest team win. And thanks a lot from the whole community for contributing your time and your experience into making this happen. Because what makes it really sort of the challenge for this industry is the fact that all the judges come from the industry. It's not just you know, random senior lawyers, but it's the people who've been through multiple cases. And so you can see that whatever decisions, if they like you, if they praise you, then it has merit, then it has legs, it has substance. That it's coming from the people who litigated games industry cases for years and years. So yes, it's something to put on the wall. Thanks a lot, and well, see you in the hearings.
Yes, all right.
And I have to say thank you to all the people that you now see on the slide who make this event possible and who make the legal challenge possible. And all the sponsors, and you can read about them, I think, in the description of the YouTube video. Thank you.